Welcome to our CFP exam prep discussion today. We're diving deep into a crucial topic that often appears on the exam: unauthorized practice of law in estate planning, specifically focusing on the boundaries between financial planners and attorneys. Let's break down what unauthorized practice of law means in the context of estate planning. Financial planners must understand that only licensed attorneys can draft legal documents such as wills, trusts, and powers of attorney. This restriction exists to protect consumers and ensure proper legal representation. Many candidates make a critical mistake on the exam by assuming financial planners can make minor modifications to legal documents or use templates to create basic estate planning documents. This is absolutely incorrect and could result in serious legal consequences in real practice. Here's a practical example that commonly appears on the exam. A client asks their financial planner to review their existing will and make some quick updates to reflect changes in their family situation. While it might seem helpful and straightforward, making these modifications would constitute unauthorized practice of law. The correct response is to refer the client to a qualified attorney. Understanding the scope of permitted activities is essential. Financial planners can discuss estate planning concepts, explain various tools and strategies, and even make recommendations about different types of trusts or estate planning approaches. However, they must stop short of drafting or modifying any legal documents. A key concept that often trips up exam takers involves the discussion of specific legal language. While planners can explain general concepts like what a pour-over will does or how a Q-tip trust works, they cannot advise on specific legal language or interpret legal documents for clients. This distinction frequently appears in exam questions. Let's look at another example. A client brings their trust document and asks what a specific clause means. Many test takers might choose an answer that involves explaining the clause to the client. However, the correct response would be to refer the client to their attorney for legal interpretation of the document. Some permitted activities that planners should remember include gathering information about family relationships, assets, and goals, discussing tax implications of various estate planning strategies, and coordinating with the client's attorney to implement the estate plan effectively. The exam might present scenarios where the line between financial advice and legal advice seems blurry. When in doubt, remember this fundamental principle. If the activity involves creating, modifying, or interpreting legal documents, it must be handled by an attorney. Think of it this way. Financial planners are like architects who can design the overall structure and explain how different components work together, but attorneys are the contractors who actually build the legal framework. Just as an architect wouldn't start pouring concrete, a financial planner shouldn't start drafting legal documents. A practical tip for the exam is to look for keywords like draft, modify, prepare, or interpret in question stems. These usually signal that the activity must be referred to an attorney. Remember, it's better to be conservative and refer to an attorney than risk unauthorized practice of law. In conclusion, always err on the side of caution when it comes to estate planning activities. Your role as a financial planner is to educate, coordinate, and refer, but never to practice law. This distinction is crucial both for the CFP exam and in real-world practice.